Hey, how you doing today? I'm B, the CEO. Welcome back to Man Views. This video today, I'll be honest, it's a very sad video. It broke my heart watching this video because a lot of fathers behind the scenes go through what you're about to witness today. A lot of times, a lot of kids are raised without their fathers in their lives, or at least like not fully involved in their lives. And the kids eventually grow up to be adults and they have this hatred in their heart for their father for not being around as much or for barely seeing the father. And I'm sure the child, the adult, possibly you watching, you probably heard your mom saying your dad was a deadbeat, your dad didn't do this, your dad didn't do that, your dad didn't want to be involved, your dad, intentionally walked away from you and I. But a lot of times that's not the truth. A lot of times these type of moms, I call them BBMs. I'm not calling all moms BBMs because there are amazing moms out there. I'm calling the ones that intentionally, out of bitterness, make a child grow up fatherless and keep a father from his child, from their child. To me, that's a BBM. That's a bitter baby mama. But a lot of time though, as a young child, you won't see that side of your mom. And to me, it is disgusting for any person, whether you're a man or a woman, to out of bitterness to keep a child from their parent that wants to be involved. But let me not go off too long. Let me let y'all watch it, and I want you to gather your own thoughts and comment below. And as always, I'll wait to the very end of the video to leave my comments and my reaction. Quick shout out and credit to Family Court Chaos. Let's get to it.
Another one Friday, and then she needed an $8,000. She needed $8,000 to represent me today, and I don't have that right now that I can spare.
Okay. Petitioner Adam Amiot is appearing in person and pro se. Respondent Crystal Trim appears with counsel Becky Mann. I think we're set here for a scheduling conference on an objection to the domestic conciliation report that was filed by Mr. Amiot's attorney at the time, which was Chris Randall, who has since withdrawn. Ms. Mann, you filed a motion to dismiss the objection.
Right.
So, Mr. Amiot, let me ask you, are you wanting to proceed on this motion and getting it scheduled for a trial?
Yes, sir. I just want a fair chance to fight for time with my daughter.
All right. Ms. Mann, and your position is?
Yes. Well, thank you, Judge. I think it's important to kind of have a global idea of what's going on in this case. In short, yes, my client, we filed a motion to dismiss Mr. Amiot's objection and motion to review. And we did that because it's in his filing of his objection and his motion was out of time pursuant to local court rule. But to give the court just another kind of a summary of things, there's one child involved, Ashlyn. She's 7 years old in kindergarten in Augusta. The parties entered into a parenting order through Texas, which was adopted in Butler County in September of 22, which outlines specific parenting time that the parties have been following. This court became involved more in March of 23 when the court entered an order that added some parental charge language by agreement of the parties regarding fostering relationships between the parties and the child, regarding language for dad to provide information as to where his parenting time is going to take place because he resides in South Dakota and travels quite a bit for his job. the court denied at that point Dad's oral motion for domestic conciliation. That was in March of 2023. The court took under consideration at that time Mom's request to modify child support, and then the court entered an order regarding child support in May of 2023 and set child support at $1,039 a month, and gave Dad all the appropriate adjustments in the worksheet and that sort of thing. And since then, in August of 2023, Dad filed his amended verified motion to modify custody and parenting time and submitted 2 proposed parenting plans. One was that he have primary custody of this child in South Dakota, and the other was that the parties share custody every other year. The court heard argument on that particular motion in December of 2023, and you, excuse me, entered an order denying Dad's motion, but determined that there was enough change potentially occurring because the child was going to enter kindergarten and that sort of thing, that this domestic conciliation was appropriate, and the parties agreed to utilize Alex Flores. At that point, Judge, the parties knew, and counsel, both counsel knew that there really wasn't an agreement to be reached, and the counsel, Mr. Randall and myself and Mr. Flores, had a conversation about how Alex could just skip the mediation phase and go straight into an investigative phase for the domestic conciliation. And he did that. And I provided the court and parties with 3 documents for exhibits. One was our exhibit A is just the letter that Alex sent to the parties on January 24th of 2024 that said, hey, we're going to skip the mediation process and skip straight to investigation. He set up a Dropbox for parties to produce documents, which he reviewed during the process, and he asked for witnesses for him to interview. That went on for the entirety of 2024. And on November 5th, 2024, Alex or his assistant emailed the parties and counsel, which is in our Exhibit B, the 39-page recommendation that he prepared as part of his duties as the domestic conciliator. The recommendation was thorough, considered both parties' arguments, wants, wishes, desires. It reviewed the court file, documents provided by the parties. I will note he did not interview any witnesses, but he identifies within the recommendation as to why he chose not to do so. But regardless, he sent us that information November 5th of 2024. I forwarded, even though my client was part of that email, as was Mr. Amiot and his attorney, I forwarded the rec onto my client and said, review this. If it's good, let me know, and we can file anything we need to in order to have it adopted by the court. If you have objections, please let me know within 21 days because we have to file a motion to review within that time frame pursuant to court order or the local court rules. My client reviewed it. She said this is fine. The recommendation essentially changes nothing, except adds in a few things about communication and that sort of thing, but doesn't change the parenting time at all. So we wait the 21 days. And actually on December 3rd, 2024, we file a Supreme Court Rule 170 notice order to adopt the recommendation because no objection had been filed by opposing counsel or by Mr. Amiot. We submitted a proposed order citing local court rule 16F2 that if no timely motion to review is filed, any objections are deemed waived. Then on the 11th, nearly 10 days later, Dad, through counsel, files his objection and motion to review. I contacted Alex Flores after I went through the court file and realized that he had not actually filed a notice of submission of the DC rec when he sent our email on November 5th. He immediately filed a notice where he certified he sent copies of the rec to the parties and counsel on the 5th of November. And that's part of the court file. And then we filed our motion to dismiss and for fees on December 31st. Your Honor, I think that the objection and the motion for review needs to be dismissed pursuant to local court rule, which I've provided for Your Honor as Exhibit C in our exhibits. It's very clear in Rule 16 how DC process is to work. It talks about in Section E, the DC is to submit written reports to counsel and, if unrepresented, to each party. In this case, Mr. Flores sent this document out on November 5th to everybody. So not just to counsel, but also to the parties for review. He acknowledged that he failed to file a notice of submission, quote unquote, promptly as required by the local court rule, but he corrected that error as soon as it was brought to his attention and certified that when he did submit the document to all of us on November 5th. Local Rule 16F1 says that if a party disagrees with a report and wants the court to review, that person shall file a motion no later than 21 days from the date of the notice of submission. I would argue, Judge, that the notice of submission, the notice that everybody received that this recommendation was done, was on November 5th, and that it's a clerical error of sorts that Mr. Flores didn't actually file a notice with the court, but that everybody was on notice that this recommendation was complete and that the 21 days starts from November 5th, 2024. And so after that requisite time frame ran, Judge, Mom, pursuant to local court rules, submitted her Rule 170 on the 3rd. And it wasn't until after Mom took an affirmative action of filing our Rule 170 that Dad then filed his objection. He should have filed his motion on or before November 26th of 2024, and he did not file anything until over a month after we received the recommendation. 16F2 says that if no timely motion or any objection if there is no timely motion, then any objection is deemed waived and either party can submit an order. That's what we did, Judge. So we've complied with the court orders. We've complied. We've submitted to the DC. We've done everything we're supposed to do. And Dad's objection and motion for review is clearly out of time, which is why we are asking the court to dismiss his motion. That's why we filed our motion to dismiss. We asked the court to approve the order that we submitted on December 3rd, which is pursuant to Rule 170, and that's to adopt the recommendation in its entirety. And Judge, we also asked the court to award attorney fees for having to respond to the motion, which was clearly filed out of time. And that we're done. No trial needs to be had, and that the DC rec is adopted as the order of the court. Thank you.
Thank you, Ms. Mann. Mr. Amiot, I'll give you an opportunity to respond.
Sir, I didn't know there was a 21-day time limit, and Chris Randall never told me of a 21-day time limit. I mean, I was trying to save up money to continue paying my attorney to do his job. You know, like she said, it took an entire year for the domestic conciliator to come up with his plan or his submission. And in that time, he had the opportunity to call my witnesses and Ms. Trim's witnesses. And he chose not to, according to that paperwork, because he felt that all he was going to hear was that I'm a good dad and Crystal's a good mom. And those both being true statements. But like I explained to him, and in all the paperwork that I turned in to him, was of the parent alienation that I was being given by Ms. Trim, her refusing to answer my phone calls, not letting me have any extra time. Hence the reason we are in this, because she has continued to deny me extra time with my daughter. 1 weekend a month is not enough for a child to be with their dad. I mean, I can't make up a whole month's worth of time in 2 days every month. And so I apologize. I did not realize there was a 21-day time frame. This is not something I do for a living. So, sir, I guess I just hope you can find it and forgive me and let me have a day to fight for my daughter or our daughter, so that way I can spend more time with her. That's all I truly want is time.
Thank you, Mr. Amiot. If you all give me just a second to look over some. Angela, the notice of submission of domestic conciliation is not in the court file. Can you see if that's in Odyssey, please?
Yes, Judge.
It was filed on December 12th, if that helps.
I see a docket note that indicates that it was filed, but it's not in the court file, and I just wanted to verify that that is in fact on file. I'm assuming you have a copy, Miss Mann.
I do.
Okay.
And I know that Angela will get it for you. It does say that, and this was filed by Alex Flores. It says that he hereby certifies that on November 5th, 2024, a copy of the DC rec was emailed to petitioner, respondent, and their counsel. Now, on this 12th day of December 2024, this notice attaching the DC rec was submitted via email to Your Honor, me, and Chris Randall.
Okay, thank you for that information. All right, I don't think I ever went off record. We're still on the record. I've had an opportunity now to look at the notice of submission of domestic conciliation recommendation that was filed on December the 12th that had not been in the court file, and look back over some of the filings in this case. According to the docket notes, back on December 5th, 2023, the court did, at that time, took up the motion to modify parenting or modify a parenting plan. There were, as Ms. Mann had stated earlier, a couple of proposals set that the court didn't feel were appropriate, but did think that domestic conciliation would be beneficial. The docket notes reflect, as we typically do when domestic conciliation is ordered, discuss the existence of our local rule 16, which is the local rule regarding domestic conciliation. The parties would split the costs evenly, and both counsel indicated that they had copies of Rule 16 at that time. Mr. Amiot was present with the attorney at the time, Chris Randall. Ms. Trim was present with Ms. Mann at that hearing. And it was then that the domestic conciliation process was initiated. Local Rule 16 does state in paragraph E on page 2 that the domestic conciliator shall, upon completion of the report, promptly submit a notice of submission of domestic conciliation report to the clerk of the district court of the county in which the action is pending. I should probably read before that. The beginning of paragraph E, the domestic conciliator shall submit a written report to the court and to counsel of record, and if unrepresented by counsel, to each party proceeding pro se upon completion of the DC process. Such report shall contain the agreements of the parties and the domestic conciliator's recommendations upon any matters in which the parties are unable to agree. Then goes on to state that domestic conciliator shall, upon completing the report, promptly submit a notice of the report to the clerk of the district court for filing. Now, obviously, that part of it wasn't done. Mr. Flores did send the recommendations to counsel and to the parties as documented in Respondents Exhibit B, email from Mr. Flores's office attaching the domestic conciliation recommendation to Adam Amiot, Christopher Randall, Crystal Trim, Rebecca M. Mann. Paragraph F, page 2 of Local Rule 16 states, if a party disagrees with a recommendation within the report and desires court review of such recommendation, such party shall file a motion with the clerk of the district court for a review of the domestic conciliator's recommendations. Such motion to review shall be filed no later than 21 days from the date of the filing of the domestic conciliator's notice of submission of domestic conciliation report with the clerk of the district court. If a disputant party files a motion for allowance to file a motion to review out of time, the court is empowered to deny such motion in its discretion as a matter of rule enforcement and then adopt the DC recommendation as the orders of the court. As previously stated, the notice of submission of domestic conciliation recommendation wasn't filed until December 12th. Mr. Flores does certify in his notice that on November 5th, he had provided copies to the parties and to counsel. The purpose of Local Rule 16 is to promptly get matters in front of the court once the domestic conciliation process is done, so the parties have orders, or if they're challenging those recommendations, to start the process to get the matter heard in a timely manner. Court recognizes that the domestic conciliation or notice of submission wasn't promptly filed. However, the court finds that the report was provided to the parties and counsel on November the 5th, that a notice or an objection wasn't filed until December 11th, which was prior to the notice of submission being filed with the court, indicating that counsel for the time had the recommendation and had prepared the information to prepare the objection, likely prompted by the Rule 170 notice to adopt the domestic conciliation recommendation. I am going to find that the notice was not timely filed, that there was a proper recommendation submitted to the parties and counsel and eventually the court. The court has reviewed the recommendation and is going to adopt those recommendations as the order of the court. Now, one thing in reviewing the Rule 170 submission, it's the court's preference that the report itself not be filed with the court as part of the court file, as it often contains the thought process going into the recommendation rather than just the recommendation and orders themselves. Ms. Mann. So I'm going to direct you prepare a journal entry that incorporates.
Redacts the italicized portion of the recommendation, which are Alex's notes, quote unquote, according to him.
Let me go through this and see if that was the primary language that I don't want filed with the court.
Okay.
Can I speak real quick?
Give me just 1 second, Mr. Amiot.
Yes, sir.
There's also some italicized portions towards the end. I guess it'd be page 38 of what I'm looking at.
Yes. I see italicized language I would take out on the first page of the recommendation, and then again on the bottom of 34, all of 35, all of 36, the majority of 38.
That would be consistent with what I'm looking at.
Okay.
All right, Mr. Amiot, go ahead.
I'm just trying to understand because you're using a lot of language I don't really understand. So basically, you're going to just accept what Alex Flores is putting out there, and I don't get a chance at trying to get more time with my daughter. It's just going to stay the Texas standard, and there's nothing I can do about that.
That's the court's order at this time, Mr. Amiot. The purpose of a domestic conciliation process is to allow the domestic conciliator to engage in the process and issue recommendations. And then if oftentimes parties will reach agreements through the process. Obviously, that didn't happen in this case. So in that event, the domestic conciliator issues recommendations, which aren't timely objected to, become the orders of the court is what's happened here.
Well, and I understand I apparently missed that date, that 21 days, and you're going to hit me with that. But at the same time, he messed up in my, what do you call it? My argument, or I don't know what you call it. But it was still filed the day before he notified the court of it, which, I mean, so you hit me with one technicality, but there's another one right there where that should allow me the time because you guys weren't notified on time. And I understand the 21 days is the 21 days, and that's it's usually black and white in court. But at the same time, like I said, he didn't do his job right by filing it with the courts, which technically I filed 1 day before him. And I understand Miss Mann's point of view of, I didn't file until after they did, which there's no argument there. Obviously, the dates are what they are. But at the same time, I was paying an attorney to do these things for me, and he dropped the ball, not me. And now he's not even here to represent me in court because he just dropped me as a client and then quit the firm. And they couldn't get me somebody to get here today that I could afford. So I'm asking the court to forgive the 21 days, because it took me, let's see, the 5th to the 11th, 26 days. No, there's 31, 26. Yeah, it took me over a month. And I apologize about that, but I mean, this at $350 an hour, a guy can't continuously fight this. I paid Alex Flores who basically sat there and mocked me in our meeting about child support and how it's about, oh, the mom's always out getting her fingernails done and this and that. Well, sir, I quit my job in Seattle, moved to the Midwest to work in this area so I could be closer to my daughter. And I have continuously and repeatedly been denied extra time with my daughter. Crystal stuck on that 1 weekend a month. And even then, when we were having 4-day weekends, I was working in Kansas City, 3.5 hours from my daughter, or our daughter. I was 3.5 hours away from our daughter. And I continuously asked every time I had a 4-day weekend if I could come get our daughter on a Friday. No was always the answer, because my court date says my court paperwork says I get Friday from 6 to Sunday till 6, when there is absolutely
Mr. Amiot, I understand you disagree with the order that I've made, but that is the order of the court. And I'm going to direct Ms. Mann to draft the appropriate journal entry, which will reflect that order.
Do you want me to submit it, Rule 170 again, and send it to Mr. Amiot with those redactions?
That would be fine, yes.
Okay, no worries.
So I know what's going on. So you're going to, 170 is coming to me and I'm supposed to,
Review it and sign it if it reflects the court's order from today.
okay, because, last time when we had this problem, I mean, you were throwing extra things in there when it came to the child support. So I just want to make sure.
This is just going
I
to
don't
reflect today.
I don't believe there's any change. This changes any child support orders that I'm aware of.
No, sir, it's not today. It was the last time Miss Mann had to write something. That's all I'm.
Okay. All right, Miss Mann, anything further?
No, thank you. Well, Judge, just the request for attorney fees.
Okay, I'm going to deny the request for attorney's fees.
Thank you.
Thank you, sir.
All right, Mr. Amiot, anything further?
How do I go about getting more time with my daughter? Can I file something? Do something?
I can't provide you with any legal advice. I would just direct that you consult with an attorney about what options you might have.
Thank you, sir.
All right, if there's nothing further, we'll be in recess.
Thank you.
Okay, where do I start? Give me a second, man, because I need to stop myself from bleeding out my frustration in this reaction video. Let's recap a few things. I would love to hear y'all comments as well, right? Your thoughts as well, comment below. But let's begin with all the foolery, right? Let's start with the judge. First of all, look at his name. Judge Crumb. All right, but anyway, let's get serious. I've seen numerous court hearings. I've been involved in some. My nonprofit company, Man Views, I coach fathers and help fathers prep up for court hearings. I deal with child custody cases on a daily with fathers with the Man Views nonprofit company. I've seen things like this over and over again where the judge will show zero sympathy for the father. I've seen it where it's the other way around and the mother would just come in and just cry and weep and all that kind of stuff, and the judge would feel sympathy and will let her slide, will forgive her on turning in late documents, or especially when the mother present herself pro se, the judges, they'll let it slide. They'll feel sorry for her. They'll really, in a way, give her what she wants. It's so rare to see a judge feel the same sympathy for a father. Now, legally, the father did not file documents on time. I will get to the father real soon. I'm going to get on what he did right, what he did wrong. But right now, we're going to stick to the judge for now, okay? Even when the father was talking, pouring his heart out, the judge, he just kept a straight face, didn't really care. At one point, he just cut him off, like, shut up, man, listen, I told you. No, he didn't really care. His mind was already made up. When he kept reading all them extra stuff, it's like, bro, you don't gotta read this. Like, you already know what you're gonna say. You're gonna tell him no, motion denied. It is what it is. All the man is asking for is just some extra days with the kid. As a mom, why would you not want to allow your child to have extra days with her dad? Let's get straight to the mom, right? Let's kind of go over her. Even though she didn't say a single word in this court hearing, but based on what I've heard from these motions, and both the attorney and the father, to me, the mother said enough. How can you, with a straight face and this Zoom court hearing, sit there knowing that you are not allowing a daughter, a 7-year-old, to have just at least 1 or 2 extra days with her dad? You are showing that your heart hates the father more than you love the child. You are putting your own selfish needs above the child. This is more of a get back revenge because y'all not together. The fact that y'all both have a child together, that means at one point you did like him. Either you loved him, you liked him. Either way, you had to feel something for the guy in order to have sex with him and have a child with him. How do you turn so cold? Put your emotions to the side. What about the child? We all know how much girls love their dad. Daughters love their father. As we get older in life, our time in the world minimizes. That means we don't have a lot of time left to be alive. You are robbing that child out of memories with her father. By the time that child get old and can finally bond with the dad and have extra days and time with the dad, guess what? The dad won't have that much time with the daughter because eventually, you could tell, he's already old. I wish some, great wealth and live forever, live a long time, but we all know that's not the case. When that dad is gone, that child gonna be like, man, I wish I had more time with my father. So those 7 years, you are robbing that child out of great memories. And who knows for how long you'll keep doing this. Based on this mother right here, you could tell she's old. You could tell this is a very old couple. And who knows how long she's going to keep doing this for. If she haven't changed, she won't change in the future. She is cold-hearted. You robbing that child of an amazing childhood. The father wants to be involved. Do you know why she don't want him to not have extra days with the child? Not only because she's bitter, but also because she knows if he start having extra days with the child, extra overnights with the child, she might lose out on some money with the child support. Because she's getting paid, $1K in child support? She knows if the father start receiving extra overnights, he can then modify that child support and reduce the amount. But I can tell from the father, I can tell that he wouldn't modify the child support. I mean, he should if he get extra overnights. But I could tell with him, all he wants is just the child. He doesn't care about the money. I mean, speaking of money, let's get back to the lawyer fees, right? I'm glad the judge denied for him to pay the fees for the lawyer fees. So that's cool. I mean, at least do that. God damn it. Like, you know what I'm saying? Have some kind of like compassion. Like, have some kind of heart. At least like have a heart. All right, but the thing that broke my heart the most for the father is, well, not only because, one, he's only seeing the daughter 2 days a month. He's only seeing the child for the weekend from Friday to Sunday. That's not enough time to bond with a child. Kids that young forget very quickly. 2 weeks pass by, a child not seeing you, they'll forget. Now, they won't forget completely, but it's hard to really bond with them. I sad to say, you can't give that man an extra day, extra weekend. And she's saying that, well, that's what the court order says. Okay, let me break down to y'all. You guys do know that the parents will always be above the time sharing plan court order. So in other words, when I say court order is not the final say, so as in, because there are different type of court orders, right? But I'm talking about the actual time sharing plan, right? Usually when you get a time sharing plan approved by the judge, it becomes a court order where parents have to follow, but they can always rearrange that time sharing plan. If both parties agree, they can overwrite the court order time sharing plan. The parents will always have the last say so on the court order time sharing plan that was ruled by the judge. A lot of parents don't know that, but you guys know that you are, when it comes to your time sharing plan, the parents are above the judge ruling. Just because the court order say the father only get 1 weekend out of the entire month with the child doesn't mean it have to be that. Both parties can say, yeah, even though the court order said I only get 1 weekend, but we together can say, nah, you know what? Our daughter needs a father, so therefore, we will make sure the daughter have you and her life for more than 1 weekend. Instead of 1 weekend, it can be 3 weekends, 2 weekends, 5 days, 1 week, or every other day, every other weekend. Who knows, right? Another thing that broke my heart for the father is that he wasted money. He really wasted his money on that lawyer. Lawyers don't really care about you or your kid. It's a business. Like he was paying that lawyer around 300 something hourly. Just because someone is a licensed attorney doesn't mean they are good at their job. I've come across terrible lawyers. When I coach fathers, I tell every father, listen, even though you have an attorney, you still have to be on top of everything. Never let an attorney care more about your child than you, because they will never care like you care. These lawyers will never care about your kids like you care about your kids. You have to be on top of things. Now, you might be like, well, B, we paying them a lot of money. Yeah, true. That's like saying you are paying daycare a lot of money. So does that mean you'll let the daycare care more about your child than you? So one aspect that the father went wrong at is he sat back and trusting the lawyer to do everything. And here's the thing. The father, he's not wrong for that. I get it. We all been there. I'm sure you've been there. I mean, you would think if I'm paying you $300 something an hour, you would do your job correctly. As a matter of fact, the higher you're paying an attorney, the higher the chance that he or she will slack off. Because you have to understand, they might have a bigger team, more clients, versus paying somebody that's like smart and upcoming, that's a lot hungrier to get the wins under the belt. So the father, that was like one flaw. He relied too much on the attorney. It's not his fault because we all have done that, and I get it. You hire somebody, you want them to do the job. What the father should do going forward is, I think everyone watching this should do if you ever get into this kind of situation, learn a little bit about the law, at least the process. Get equipped in what's going on with your case. Don't rely on the attorney only. Email them. Hey, just double checking, man. Did you send that? So going forward, if I'm the father in this case, here's what I will do. It's hard to really get a whole new attorney because money just wasted. Now, what I would do is I would report the lawyer to whatever the bar is for them, for that lawyer, report that lawyer. That's what I would do because you didn't do your job correctly. You cost me money. Go over the contract that you signed. If there's like a flaw that he did, sue him. That's what I would do. I would sue the lawyer. If I got look, I'll rep myself. I have to, but I'm gonna sue you. At least waste your time. As the father, other things I would do is try and get closer as you can near your child, and keep fighting. Get that time sharing plan modified to get more days, more percentage. Learn more about the law in your state, the family law in your state. And for every man watching this, to all the dads watching, unfortunately, the court, the family law, the judge, there's no sympathy for us. It doesn't work like it'll work for the mother. The mother could have been the one here whining, crying, whole sob story, and she would have got what she's asking for, or at least close to it. For a man, the world don't care about man. And the sad thing is, men get abused too. Men get abused the most in family court. Abuse is not only physical. Abuse is emotional, mental, financial, spiritual. The mother denying that man time sharing, that is abuse. Matter of fact, her denying that the daughter to bond with the father properly, that's honestly child abuse, emotional abuse. Why? Why are you doing that? As far as a lawyer goes, or attorney, I mean, she know damn well she could have said, man, listen, let the man get extra days. But I guess she's getting paid to do her job, so I get it. It's like whatever. But she only care about the kid or the father or the mother. Once the mother stop paying, she'll be out too. And of course she could afford an attorney. I mean, the man paying you $1,000 a month of child support. The man's being gutted. Being gutted. He did the right thing. He got the attorney. He's fighting. But you can't rely solely on the attorney. You have to be on top of things. You have to put that attorney to work. Hey, by the way, did this get turned on time? Where are we? What's the status? And if you got to reach out to your attorney every time they're not doing their job, hold them accountable. Bring them to court. Sue them. Last thing I'm going to say is the reason why I had to comment on this video because I want this video to be on the internet for a long time. Because I want the daughter to one day, when she gets a little bit older and can be online at the proper age, I'm praying she come across this video like, oh wow, hey, whoa, that's my dad. And that's my mom. Oh, so my dad did fight for me. Because I'm sure the mother going to tell the daughter, your dad's a deadbeat. He's not supporting you financially. Even though she's getting child support, she's going to say he's not giving her a dime to support you. He's not this, he's not that. She's going to brainwash the child. But hopefully the child can go online and be like, whoa, wait. Oh, so, whoa, that's my dad. My daddy, he was fighting for me. What? So this is very important for me to actually leave on YouTube. You know what I mean? Like, I am a father. I feel his pain. One day I will tell you guys my personal story on why I created Man Views, why I'm doing all this YouTube channel to put a spotlight on what fathers go through. I'll do that one day, but not today. Because today's not about me. It's about that child and that father in this video. But listen, what's your thoughts about this? You know, this was a very tough one to watch. I'm gonna be honest. But as fathers, we have to come into these court hearings with evidence, with documents, with witnesses, we have to be on point. Emotion doesn't work with fathers. It's not gonna work. I'm gonna be honest right now with y'all. To any dads watching this, emotions doesn't work. That's not for fathers in the courtroom. For the mothers, yes, it works for the mothers. For let's think about society as a whole. When's the last time you saw the world feel sorry for a man crying or feeling sad? When's the last time you saw the world caring for a father being sad? It doesn't work. In these court hearings, you have to come with concrete evidence. You gotta be as perfect as possible. Get everything done on time. Do as much as you can to be aligned with the actual law. Because when it comes to fathers, the judge will actually go word by word in the textbook of what the law is. So when they tell you no and they deny your emotions, you can't say, well, he's not biased. That's the law. He doesn't hate father. The father did, submit the document, a month later. He had to deny the motion. That's why you gotta be on your P's and Q's and be as perfect as possible. Don't leave no cracks. Not one crack. Even if you can't afford an attorney, become your own attorney. With that being said, what's your thoughts on this? Let me know. Did you agree with the judge or disagree? What's your thoughts about the mom and her attorney? What about the father? Do you feel bad for the father? Do you feel like, well, it is what it is, that's his mistake? And what's your thoughts about the father's attorney? Even though he's not in here, but for him to just drop the man, right before the hearing. What are your thoughts? Do you agree with me? Do you disagree? And it's okay to disagree. We all can be positive and not be negative when we have these type of dialogues. With that being said, listen, put the kids first. Love the kids more than you hate each other. The kids deserve to bond with their father and their mother as well, with both parents. Let the child decide who he or she think is the bad parent. Don't force your pain or sad emotions on a child. Let the child breathe and live their lives to the fullest. Don't put your scars on that child's skin. With that being said, have a wonderful day. Like, comment, and as always, subscribe. Peace.